Have you ever been overcharged by a corporate cartel? Seriously, think about it. Because every single day, countless people and small businesses end up paying artificially inflated prices thanks to hidden monopolies and shady price-fixing schemes. But actually fighting back against these corporate giants? Yeah, that has traditionally felt a lot like David taking on Goliath, except David is armed with nothing but a giant mountain of confusing paperwork and some seriously sky-high legal fees.
So, welcome to The Explainer. Today we're diving into a pretty dense 90-page government proposal from July 2026. It's called Swifter and Simpler Competition Redress. Now, it's actually a fascinating read, so let's figure out what these targeted reforms really mean for us. The whole goal here is to fix a broken, super sluggish legal system and finally tip the scales back in favor of the consumer.
Okay, let's dive right into this. Here's our roadmap for today. First, the slow justice problem. Second, upgrading consumer class actions. Third, funding the legal fight. Fourth, protecting cartel whistleblowers. And finally, streamlining regulatory appeals.
So, Section 1, the slow justice problem. Let's look at exactly why the current system fails.
Now, before we look at the solutions, we really need to understand exactly why the current competition law framework is just outright failing everyday consumers. The whole system was originally designed to hold anti-competitive behavior accountable, right? But in practice, getting actual cash back into the hands of victims is incredibly difficult. I mean, just look at this staggering number, £130 billion. That is the estimated cumulative total of damages claimed since 2020 on behalf of over 655 million class members. But what does that massive number actually mean for your wallet? Are you, the consumer, actually seeing any of this money?
Well, sadly, no. Take the recent Gutman train ticket case as a prime example of this massive failure. In that settlement, the stakeholders, so meaning the lawyers and the funders, they walked away with over £10 million. But get this, less than 1% of the actual consumer class claimed their share. Less than 1%. That left only about £216,000 distributed to the actual victims. So the system is generating these massive headline-grabbing lawsuits, but it's completely failing to actually distribute the justice.
And the government fully recognizes this. As the Secretary of State for Business and Trade explicitly states in the foreword of this proposal, nobody wants to be stuck for longer than necessary in litigation, regulatory processes, or appeals that are confusing, costly, and time-consuming. They hit the nail on the head there. The government's mission here is pretty simple. They want strong enforcement and fair outcomes, absolutely, but they are saying a hard no to excessive costs and wasted time.
Moving on to Section 2, upgrading consumer class actions. It's all about empowering consumers.
So if the current system is way too slow and heavily favors the legal stakeholders over everyday victims, how exactly does the government plan to build a better slingshot for us to fight back? Well, it starts with refining something called an opt-out collective action. Let's clearly translate that dense legal jargon for a second. Basically, this is an automatic class action lawsuit. It means a single claim is brought forward for a massive group of people who all suffered a small individual loss. And the really beautiful part? You don't even have to sign up or, opt in to be included in the class. It's an incredibly powerful tool. But right now, the threshold to get these cases approved or certified by a judge is honestly just too low.
So the crucial takeaway here is that the new rules are going to tighten this all up. First, courts will now have to consider the absolute suitability of a claim. What does that mean? It means evaluating its actual prospects of success and its proportionality, not just looking at whether a group lawsuit is slightly better than an individual one. Second, they're going to put much greater weight on a strict cost-benefit analysis. This is huge because it ensures that cases aren't allowed to proceed if they're just going to make lawyers rich while delivering absolute pennies to the victims. And finally, they must ensure there is sufficient evidence to actually calculate the aggregate damages right from the start.
All right, Section 3, funding the legal fight. Let's talk about paying for these complex cases.
Now, even with much better rules in place, bringing a lawsuit against a massive, incredibly well-resourced corporation costs millions of pounds. So how do everyday consumers pay for this? Well, the government is proposing a real game changer here, and this brilliantly illustrates the shift. Over on the current system side, contingency fees are outright banned in these opt-out cases, which has honestly led to highly unstable funding markets. But look at the newly proposed system. The government wants to officially allow damages-based agreements, or DBAs. Essentially, these are your classic no-win, no-fee structures. This move directly mitigates a recent, highly disruptive Supreme Court ruling known as PACAR, That ruling basically threw the enforceability of a ton of litigation funding agreements into total question. So, by officially lifting the ban on these no-win, no-fee agreements, the government hopes to encourage real market competition for legal funding. And what this means for us is that lower-value claims, cases worth maybe 200 million instead of 500 million pounds, will actually have a fighting chance to get heard in court, simply because the financial risk for the lawyers and funders is structured in a much more practical way.
Moving to Section 4, protecting cartel whistleblowers. It's time to talk about exposing those secret cartels.
So, as you probably guessed, cartels are incredibly secretive. They certainly don't leave convenient paper trails lying around. So insiders are desperately needed to expose these illegal price-fixing rings. To get them to talk, the government relies on something called the Type A Leniency Program. And here is exactly how it works. Step 1, you have to be the very first person or company to report a cartel where there's no pre-existing investigation. Step 2, you have to provide concrete, actionable evidence of the illegal activity. And Step 3, you gain Type A immunity. Now, right now, that grants you immunity from criminal prosecution, those massive regulatory fines, and director disqualification. Sounds like a sweet deal, right? Well, there's a huge catch, and it is heavily impacting the number of people actually willing to step forward.
You see, even if a brave whistleblower avoids prison and avoids those massive government fines, they can still be completely sued into bankruptcy by private citizens in civil court through those exact same massive class action lawsuits we were literally just talking about. It's terrifying. Because this immense fear of civil lawsuits is currently stopping whistleblowers dead in their tracks, the government is proposing a pretty radical fix: full immunity from civil litigation damages for Type A leniency applicants. By completely removing the threat of these private lawsuits, the government really hopes to crack these secretive cartels wide open once and for all.
And finally, Section 5, streamlining regulatory appeals, all about saving time and money.
This last part of the proposal looks at how the underlying bureaucratic plumbing of regulatory appeals is getting completely rewired. Currently, when a giant utility company wants to appeal a regulatory decision, those appeals very often go straight to the Competition and Markets Authority, or the CMA. But here's the problem. The CMA is primarily an enforcement body. Having them act as a judge totally distracts them from their main job, which is investigating markets. So, the proposal brilliantly solves this by shifting these appeals away from the CMA and over to the Competition Appeal Tribunal, or the CAT. Now, the CAT is a specialist judicial body. They are literally built from the ground up for efficient case management, and they actually have the dedicated economic and legal experts required to resolve these incredibly complex disputes quickly.
What's great is that this shift harmonizes the entire system across our most vital everyday utilities. We're talking about moving appeals to the CAT from major economic regulators like Ofwat for water and sewage, Ofgem for energy, the CAA for aviation, and Ofcom for your postal and telecom services. By consolidating this whole process under one roof, it's going to create a much more accessible, transparent, and consistent appeal system, which ultimately means regulatory certainty isn't just endlessly delayed by red tape.
Wow, okay, we have definitely covered a lot of ground today. From stopping frivolous lawsuits from completely draining our compensation funds, to empowering the whistleblowers who expose cartels, right down to untangling all that bureaucratic red tape. So what does this all mean for you? I want to leave you with this final, provocative thought. If this government consultation actually becomes reality, and these rules pass, making the legal system faster, fairer, and way easier to navigate, will you finally claim your fair share? Thank you so much for joining me for this explainer. I really hope you found this breakdown as fascinating and empowering as I did.